Contract Law by Matthew Blyth.
And Kadon Barnwell.
Why and how contract law has developed and why is it important? Contract law was created to reach an agreement, bargain, or deal with another party. Contract law may be viewed economically as well as culturally. Contract law monitors the deal of goods and services. As we grow into a more advanced way of living, where we depend on each other to grow, establishing guidelines on agreements other than taking your word is critical as we develop in the capitalistic economy. In addition, contract law reduces the cost of economic transactions. When a contract is agreed upon, the terms and conditions are spelled out on paper. So if one violates the contract, it is easy to pinpoint where and how they violated the contract. Last is everything is on record. Knowing what parties have done in the past allows you to plan the transactions more carefully and avoid potential pitfalls.
What is a contract? Contracts are written or verbal promises or set of promises for the breach of which the law gives a remedy. They are the total legal obligation of both parties which have agreed on the terms that are within. Contracts function as a binding for the parties to which they are not to break a promise or breach the terms that they have agreed on. Breaching of a contract will result in failure of exchange of goods or services that parties had promised each other. The consequences of a breach usually causes an inconvenience as well as a detriment to either one or both parties. There are 5 elements of a contract: offer, acceptance, capacity, consideration, and legality. Offer in a contract is when one or both parties have a good or service that they want or are in need of and are willing to make an exchange with another. One party will start by determining what it is that they are in need of and if the other party can provide it. With this in mind, a party will make an offer, making them the offerer, to another party, who's the offeree, in which they intentionally communicate what it is that they are exchanging. Acceptance: an unequivocal and absolute acceptance of exchange in its entirety. Capacity: determination of one's legal ability to enter a contractual agreement. Factors such as age, mental state, and competence are taken into consideration. Consideration: consideration is something of legal value that is being exchanged within a contract. Components of consideration include a legal detriment, adequacy between parties, and legal sufficiency. And legality: legality is determining if what is in the contract is against the law or public policy.
This is a real-life example of the 5 elements of a contract. Offer. Kadon makes an offer of $12,000 to buy Matt's car in its current condition. Acceptance. Matt agrees on the sale of his car for $12,000. Capacity. Matt and Kadon are legally able to enter a contract with each other because they are of a mature age and are both competent. They understand the consequences of the contract and its terms. Consideration. $12,000 in exchange for Matt's car. And legality. The sale of Matt's car is legal because it's the sale of a motor vehicle and it does not go against the law or public policy.
How contracts are classified. Contracts come in all different shapes and sizes. Contracts can either be written, oral, explicit, or none of the above. Contracts can be formed, expressed, or enforced in many different ways. Contracts are classified along 4 different dimensions. They are explicitness, mutuality, enforceability, and degree of completion. Explicitness: contracts could or cannot be spelled out exactly. When a contract is spelled out exactly, that is an express contract. An example of express contract is the offerer stating, "I want to buy a stereo for $500, and the offeree stating, "Deal, come pick it up tomorrow." It could be written or orally. When it is not expressed, a contract could be implied. There is implied in fact and implied in law, which is also known as a quasi-contract. Implied in fact means that although you haven't discussed the terms, it could be if there is intention between both parties. Example of an implied in fact contract is going to an auto body shop and because your car has a dent and telling them to fix it. It's implied that you're going to pay for the new part and it is also implied that the offeree or the body shop is going to fix the dent. Implied in fact is a little different. It is not technically a contract, more so a fiction that the courts create to prevent injustice. An example of this would be if someone is choking on food and an on-duty police officer is present. He has permission to perform the Heimlich maneuver. He does not need permission from the choking person because it is implied they need help. So if this goes to court, there would be no argument that the permission wasn't there. Moving on to the next category, and that is mutuality. By definition, mutuality means the sharing of feelings, actions, or relationships between two or more parties. In terms of contract law, there are two different categories of agreements. First is bilateral contract. A bilateral contract is a promise exchanged for a promise. For example, I promise Kadon to drop off firewood if he promises to pay me when I get there. The second part is unilateral. Unilateral is when one party's act is exchanged for a promise. An example of this is I pay Kadon for the promise of him to drop off firewood for next week. Next, we move on to enforceability. Enforceability is broken into three categories: void, voidable, and unenforceable. A void contract is when one or more elements of a contract are missing. So if you are lacking consideration in a contract, the contract is off, or better known as the contract is void. Voidable contracts is when one party may become unenforceable to the contract. This is usually the case when a minor avoids a contract because by law, minors are not bound to any contracts. When this happens, the contract is restored to original conditions. The last portion of enforceability is unenforceable. An unenforceable contract is exactly what it sounds like. It is when a contract is not forced by law. For example, someone owes you money, but it takes you 5 years to ask for the money. The statute of limitations has run out and nothing can be due to get your money back. Moving on to the last part of contracts, and that is degree of completion. The goal of a contract is to make sure both sides perform their end of the deal. When the contract is fully performed, it then becomes an executed contract. And when it is in the process, it is an executory contract.